You see the white hat there to the left of that SUV. This is the gentleman that's going to walk around to the driver's side with a gun pretty plainly in hand and tap the driver's side window. You do see this dude get shot. Likely, it appears, with fatal results. So if you're not ready for that, this was your warning. There's other content out there on the internet to watch, but that's what we will be observing here. Here we go. Oh, there's no audio, by the way. There he is. Gun comes out right there, cycles the slide, taps on the glass, tap, 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 pop, 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 pop. Turns out the person inside the green SUV has a gun too. This guy goes for a short jog, gets dizzy, falls down, and that's it. He's just laying there in the roadway, and everyone's just driving about, going about their business. 17 seconds from when this guy decides he's going to play tough, he's going to F around until less than 17 seconds, right? When did the shots come through the window? 8 seconds. From when he, let's see, he presents the gun here. That's 2 seconds in. And he catches what appear to be fatal rounds 8 seconds in. So that's a 6 second gap. That's how quick it went bad for him from his poor decision to present a gun to him being fatally shot. So notice he taps on the glass here, and then he actually lowers his pistol to his side. And then the people inside the SUV shoot him. Is that a problem from a legal perspective? Well, of course, the easy way to understand all of this is, as usual, to apply our 5 elements of self-defense analysis framework. These are the elements that make up any use of force justification for defense of yourself or other persons. Those 5 elements. That's the good news. There's not 500 elements of a claim of self-defense. There's not 50 elements of a claim of self-defense. There's only 5 and only up to 5. Sometimes one or more of those elements is legally waived for one reason, in which case there could be 4 elements required, or 3 elements, or 2, or even sometimes just 1. But the most you have to worry about is 5. And those are, by the way, we make this cheat sheet freely available. It's right there on the screen. lawofselfdefense.com/elements. It's just a PDF download, lists the 5 elements, provides a brief description of each. The key is, whichever of the 5 elements are required, well, obviously they're required. And for a prosecutor to defeat a claim of self-defense in court at trial, he has the burden of disproving self-defense beyond a reasonable doubt. That doesn't mean disproving every element of self-defense, because these are cumulative. He only has to disprove any one of the required elements of self-defense. And if he does that, your claim of self-defense doesn't just diminish, it collapses entirely. So from a prosecutor's perspective, when he gets that investigative report from detectives, that's what he's looking for. He's looking for evidence, building blocks of evidence he can use that lead him to believe that he has a reasonable prospect of disproving any one of those elements beyond a reasonable doubt. And if he feels he can do that, he feels he can win at trial. Because remember, when you claim self-defense, you're not saying it wasn't me. You're not saying you have an alibi. You were someplace else. You're saying the opposite of that. You're saying it was me. I shot that guy and killed him. But I did it with the legal justification of self-defense. It's not coherent to try to argue it wasn't me and I did it in self-defense. So implicitly, at the very least, if you're claiming self-defense as a legal defense, you're implicitly conceding not to having committed a crime, but to having engaged in the underlying conduct that's the basis for the criminal charge against you. You're saying, I shot that guy, but with the legal justification of self-defense. And the prosecutor knows that if he can defeat your claim of self-defense, so that part of your argument goes away, all that's left is effectively a confession, right? I shot that guy and killed him, period. If self-defense has been defeated as a legal justification. So if this person driving the SUV who fired those shots out the window, assuming this is investigated, and the prosecutor gets that investigative report, that's what he's looking for in this case. Are there one of those elements that I feel I can disprove beyond a reasonable doubt? Now, of course, this event probably did not take place in the US. Many of these videos come from Brazil and other parts of South America, but for our purposes, we're going to pretend that this occurred in a US jurisdiction. So, what are the 5 elements? Well, they are innocence, imminence, proportionality, avoidance, and reasonableness. And let's step through each of those. So, innocence has to do with whether or not you or the other fellow was the initial physical aggressor in the confrontation. I wish there was a medium-sized setting for this. There really isn't. So let's go back to the video here. So who was the initial physical aggressor? The first person to use or threaten to use physical force in this confrontation? I'd suggest it was the guy in the white hat. When he does this, when he pulls out his gun. Could there be a justified reason for his pulling out his gun? Well, it's hard to imagine given his conduct here, right? He's not trying to get away from this SUV. He's escalating the confrontation. So I think it's reasonable to infer based on this evidence that this dude was the initial aggressor in this confrontation. And therefore that the person inside the SUV has the element of innocence in their favor. Not a viable target of attack for a prosecutor to disprove beyond a reasonable doubt on this evidence. What about the next element? Imminence. Imminence has to do with whether or not the threat you're facing is actually occurring or immediately about to occur. So this guy comes around, gun out, cycles the slide, taps on the window with the muzzle of the gun, and then lowers his hand back to his side. Is that a problem for the defender in the SUV? He's not being shot at, right, in the moment. But is he facing an imminent threat? Would it be reasonable to infer from this guy's conduct that he's presenting himself as an imminent threat to the people inside the SUV? How do we evaluate imminence? Well, it has its own sub-elements: ability, opportunity, and jeopardy. When you have AOJ, you have an imminent threat. Ability. Does this guy have the ability to cause harm? Well, everybody has some ability to cause harm, right? So the real question is it merely non-deadly harm or is it deadly harm? We'll address that when we get to the element of proportionality. Let's assume everybody has some ability to cause harm. Opportunity. Do they have the opportunity to bring that ability to bear? Where here the ability is the gun. Does he have the opportunity to bring the gun to bear? Sure. He's standing right outside the glass. Jeopardy. Is he conducting himself in such a way that a reasonable person would infer that he intends to bring that ability and opportunity to bear against an innocent person? Because, of course, if he were just a uniformed police officer just walking on the sidewalk here, he'd have ability and opportunity, but presumably would not be conducting himself to represent jeopardy. Well, this guy's certainly presenting jeopardy, right? He's pointing the muzzle at the people inside the van. Ability, opportunity, jeopardy. We have an imminent threat here. So we have innocence, we have imminence. The next element is proportionality. Are we dealing with a non-deadly force threat or a deadly force threat? If this guy is only presenting as a non-deadly force threat, you could only use non-deadly force to defend yourself. But he's not. He's presenting as a deadly force threat. He's presenting a gun at the innocent victims. And because he's presenting as a deadly force threat, he can be defended against with deadly defensive force. The element of proportionality also soundly within the defender's favor. By the way, even if he was presenting with only non-deadly force, if he attempts to breach the vehicle, in most jurisdictions, it would create a legal presumption that he intended to cause death or serious bodily injury to the people inside, just as if he were breaching a home. So it's possible there are circumstances here in which the people inside the SUV would be privileged to use deadly defensive force, even if explicitly it might not be clear that this guy was presenting a deadly force threat, because the breach of the vehicle would be sufficient to create a privilege to use deadly defensive force. So we have innocence, imminence, proportionality, all on the side of the defenders inside the SUV. The next element is avoidance. Avoidance has to do with whether or not you have a legal duty to retreat before you can use deadly force in self-defense. There's only 11 states that impose this legal duty to retreat. 39 states are stand your ground states where you don't have a legal duty to retreat before you can defend yourself in an otherwise lawful act of self-defense. Let's pretend this happened in a duty to retreat state. Does the driver of the SUV have a legal duty to retreat? Well, you might have a generalized legal duty to retreat if you're in a duty to retreat jurisdiction, but that duty only applies if, one, it can be done with complete safety. You're not required to increase your jeopardy in an effort to retreat. And two, if it's practically possible for you to safely retreat. So looking at this traffic, it's easy to imagine that there's another vehicle immediately in front of the SUV and they have no place to go. Well, if retreat would not be practical, it's not possible, then the legal duty doesn't apply. Also, are you going to drive away faster than a bullet? So often when you're faced with the muzzle of a gun, retreat's not possible anymore, not safely possible anymore. And therefore you would not have the legal duty to retreat, even if you were in a duty to retreat jurisdiction. So innocence, imminence, proportionality, avoidance, all in favor of the defense here. What about reasonableness? Well, reasonableness has two facets. One is subjective reasonableness. Do you have a genuine good faith belief in the need to act in self-defense? And we kind of have to presume that's the case unless we have evidence to the contrary. What kind of evidence could contradict a subjective belief in the need to act in self-defense? Well, if you go to the fight, if there's video of you advancing towards that other person, going to the fight never looks like self-defense. And it's inconsistent with a subjective fear of deadly force harm. If you think someone's trying to kill you, you're generally moving further away from that person, not getting closer to them. But let's assume there exists here a subjective, genuine, good faith belief that they're facing a deadly force threat. The other half of the reasonableness element is, well, is that subjective belief objectively reasonable? In other words, is it irrational? Is it speculative? Or would a hypothetical, reasonable, and prudent person in the same circumstances have shared that subjective belief? So it has to be subjectively reasonable and objectively reasonable. Well, we're presuming here a subjective belief in harm. Is that belief reasonable? Well, you're looking at a gun. They're not imagining that this guy might have a gun. He's not holding a slice of pizza and they irrationally are perceiving it as a gun. The guy's actually pointing a gun, handling something that in exactly the same manner as a gun. Even if this were to turn out to be a fake gun, if it's being presented in a manner that a reasonable person would perceive it as a real gun, you can defend against it just like it's a real gun. The threat you're facing doesn't have to be actual. It has to be reasonably perceived. You're allowed to make mistakes in self-defense, so long as the mistakes are reasonable mistakes. In any case here, of course, we have no indication that this is anything but a real gun here. So subjective reasonableness, objective reasonableness, innocence, imminence, proportionality, avoidance, reasonableness, all soundly in favor of the defender here. So when the prosecutor gets the investigative report about this event and looks at this video, which of those elements could he have a viable prospect of defeating, disproving beyond a reasonable doubt in court? Well, on the facts and the law, none of them. So that's a pretty robust claim of self-defense. Now, does that mean that this driver, this SUV, could not be prosecuted? No, a prosecutor can take you to trial anytime he wants, essentially. Goes to a grand jury only hears his side of the story, gets an indictment, and off to trial you go. Now, he may not have much of a chance of winning a trial, but we see plenty of cases, the George Zimmerman case, the Kyle Rittenhouse case, where that was true, unlikely to win on the legal merits of the case, but sometimes these cases are brought for political reasons, purposes of political capital, purposes of satisfying the mob that's outraged over a particular use of force event. And even if the prosecutors, first of all, they always have some chance of convicting at trial. No matter how innocent you are, there's a greater than zero risk, somewhere between 10% to 50% chance you get convicted at trial, even if you're actually 100% innocent. Because the people evaluating your use of force afterwards, particularly the jury, they weren't there. They don't know what happened. They don't have any personal knowledge of the event. They're just relying on what they're hearing in the courtroom. Prosecutors telling a story of guilt. This killing was unlawful. Defense counsel is telling a story of innocence, and the jury has to decide what they believe. Do they believe the state has disproven any one of these elements beyond a reasonable doubt? And if it is a politically energized case, if the races of the parties are different, then we have to risk not only the political considerations of the jury, but potentially the political considerations of the judge and the political considerations of the prosecution, of the judge, and of the jury. They may be politically motivated to turn a blind eye towards your legitimate claim of self-defense. Innocent people get convicted all the time, even in non-politically energized cases. But imagine you have a case where for a year or a year and a half or 2 years, this defender was demonized in the media as a racist, or whatever negative connotation can be created, building that kind of narrative. And that's what the jury pool hears for a year and a half, 2 years. You're a monster. You're a racist murderer. You're going to get an unbiased, impartial jury in that trial, especially a jury that knows that eventually their names will be revealed. And if you're acquitted, the acquittal was unanimous. Every single one of them voted for acquittal. They've got to go back to their communities and be known as the person who acquitted what everyone believes to be a racist murderer. So I talked about this in yesterday's video, the airport fight video, that if you can, I generally caution that you use as little force as possible to minimize your legal liability, your legal risks in these kinds of cases. The more force you use, the more attractive you become as a target for prosecution, the more likely it is a case could be politically energized in the way I just described and all the risks that come with that. But of course, I condition that caution on using as little force as possible by adding consistent with your safety. Don't increase your jeopardy in order to reduce your legal liability. The first priority has to be winning the fight. If you don't win the fight, nothing else really matters. And in this case, if someone's tapping on your car window with a gun, can you really use anything less than deadly force? Deadly defensive force? I would think not. Now, there's also tactical considerations here, right? This guy walks up to your car window, taps on the glass with the muzzle of his pistol. Do you even have a gun? Do you have a gun? Is it home? Is it in your car? Is it accessible in your car? Is it on your person? Is it accessible on your person? Have you ever practiced presenting a pistol while seated in a car and not getting it tangled up in the steering wheel? I mean, I have lots of times, especially, I've had practice shooting guns from cars through competitive shooting sports like IDPA. By the way, they're loud. Guns inside a car, do you have a hearing protection on? Nope, not in real life. Of course, when you're training, you'll be wearing hearing protection, but just be prepared. Guns are super loud inside the confined spaces of a car. So if you don't own a gun, or your gun's at home, or it's not accessible, you don't have any options here. You're at this guy's mercy, right? So keep those tactical considerations in mind as well.